Chair, good afternoon, ladies and gentlemen. House Committee Bill 9 is a joint resolution proposing an amendment to the Iowa Constitution that would read as follows. The right of the people to keep and bear arms shall not be infringed. The sovereign state of Iowa affirms and recognizes this right to be a fundamental individual right. Any and all restrictions of this right shall be subject to strict scrutiny. This resolution has already passed through the 88th General Assembly. If passed by this General Assembly, it will go before the people for final approval. Mr. Chair, this concludes my opening remarks.
Are there additional comments? Representative Russell Purcell.
Thank you, Mr. Chair. I'm choosing to be far back just because of safety reasons. I appreciate you bearing with me because I do not have a table or a desk. Republicans are back again this year with a bill to eliminate background checks, remove the requirement for a permit to carry a concealed handgun, and allow guns in our safest spaces: schools, hospitals, child care centers, and courthouses. The constitutional amendment will likely take down every reasonable gun law on the books because it raises the legal standard beyond the Second Amendment of the U.S. Constitution. If Republicans wanted to protect our Second Amendment rights, the language of the Second Amendment provided a great example of how to do just that. Unfortunately, Republicans have insisted on using strict scrutiny as the standard for reviewing laws. In this time of increased divisiveness, after the U.S. Capitol was stormed and defiled by an armed mob with violent intent, we need to step back. This is not the time to rush a constitutional amendment to eliminate Iowa's common sense gun laws. A Washington, D.C. police officer who tried to stop rioting Trump supporters from entering the Capitol building on January 6th has revealed that rioters shouted, "Kill him with his own gun," as he lay injured on the ground. These are chilling words. Too many people are turning to force as a response to not only fears, but also disagreements. Every 39 hours, a person is killed with a gun in Iowa. There's much more that state leaders can do to protect our communities and reduce the number of gun deaths in the state. And House Study Bill 9 would keep us from doing that. The NRA calls the strict scrutiny amendment an iron wall around gun rights. It is estimated that only 30% of laws withstand a strict scrutiny challenge. Therefore, the concern is real that House Study Bill 9 will eliminate background checks, will remove the requirement for a permit to carry a concealed handgun, and allow guns in our safest spaces: schools, hospitals, child care centers, and courthouses. One fundamental freedom every American should have is the freedom to be safe in our homes, neighborhoods, and communities. Freedom to live our lives without the constant threat of gun violence hanging over our heads. The reckless disregard for the gun violence that plagues so many people's lives is morally bankrupt and doesn't have anything to do with protecting freedom. The fact that military-style assault weapons and high-capacity magazines are routinely available to people is alarming and surprising to many Americans. Last year, on the Senate floor, Senator Schultz said that he didn't think this legislation would allow him to own a bazooka, but he sure wished it did. With an iron wall around gun rights, we don't know how far the courts will go in allowing more and more dangerous weapons. Even without a bazooka, semi-automatic military-style assault weapons with high-capacity magazines are readily available to Iowans. Where does it stop? 86% of Americans and 82% of gun owners support requiring all gun buyers to pass a background check no matter where they buy the gun and no matter who they buy it from. Nobody Nobody knows how our Supreme Court will interpret Iowa's common sense gun laws using this strict scrutiny constitutional amendment. Nobody knows. We do know that 70% of laws are overturned under a strict scrutiny standard. Yesterday, President Biden called for truth over lies. As legislators, you have a responsibility to state your clear intentions. What is the end game? Constitutional carry? Constitutional carry is the legal carrying of a handgun, either openly or concealed, without a license or permit. Instead of a constitutional amendment, why don't you be honest with Iowans and bring this constitutional carry bill to the House floor? You are punting this to the courts to decide. Republicans on the far right are always criticizing radical activist judges for not following the text of the Constitution. But then they justify this extreme amendment by relying on those same so-called activist judges to save it. The truth is that we don't know how judges will interpret it. We can't take that chance. Last night, former Presidents Bush, Clinton, and Obama came together and asked us to come together. Former President Bush said that if more Americans would love each other as themselves, a lot of our tensions would go away. This is a fundamental value we have moved away from. This bill divides us. It pits neighbor against neighbor, and I recommend a no vote. Thank you, Mr. Chair.
Additional comments? Representative Ames.
Okay.
Thank you, sir.
Thank you. Oh, thank you. Good. I didn't stand up very long, so this is very nice. Will Representative Holt yield?
Yes.
Thank you. Why aren't we looking at putting the Second Amendment from the U.S. Constitution into our Constitution? Why do we need different language?
Well, that's an excellent question. We have the benefit of 44 other states who have similar language, Second Amendment language to the United States Constitution. And unfortunately, we have seen how courts have allowed a number of gun control laws, onerous gun control laws that infringe on the fundamental right to keep and bear arms. So the language that we have, which is the strict scrutiny language, is the result of knowing what has happened in 44 other states. And so the strict scrutiny language, which I think should be applied to every fundamental right, such as the right of free speech, the right of peaceably assemble, the right of freedom of religion, all of these are fundamental rights that should always be subject to strict scrutiny, meaning the government has a compelling interest and that they must narrowly tailor their laws to fit that compelling government interest as it applies to fundamental rights.
And can you give me an example or examples of laws that didn't stand up in states where they just adopted the U.S. Constitutional Amendment?
I can certainly get you a list of those. I don't have it with me today.
I would appreciate that.
Get you a list that there's lots of them in 44 states.
I would appreciate that. And one more question. What other states use the strict scrutiny language?
There's a couple of other states. I think there might be 3 or 4 states that have strict scrutiny language. I can get those state names for you.
Okay. Okay, well, certainly, we all want people to be able to protect their homes, their families, themselves. And Iowa's gun laws do that. In fact, do that very well. If you look at Chapter 704, I think 704 or 724? 704.
24.
Thank you. Of course we want people to be able to protect themselves, you know, but I don't understand why we would be using the language of strict scrutiny, which is generally reserved for issues regarding protected classes like civil rights, for races and genders and religion. That's what strict scrutiny is generally used for. And I would like to know, and I don't know if you're the one to who can tell me this, but why? I believe that people have a right to their guns, except for people who don't have the right to their guns, and those are pretty narrowly defined in our state. So my question is, what are we trying to do here? I mean, Iowa has good gun laws. I ask everybody who writes to me about gun laws if they've ever had trouble getting a gun. And their answer is generally no, unless they're a felon, or unless they threaten their family by being a batterer. But most people, I know, I had one guy tell me that he couldn't get the rifle he wanted to use for deer hunting, but then he finally told me that it was because the manufacturer was back ordered. So it had nothing to do with our laws. So I believe that we have good gun laws in Iowa, that people are allowed to protect themselves, their families, their homes, their businesses, and anybody that they see threatened on the street. That's right in the Iowa law. And I will oppose this bill because I do not see that we should be extending the measure of strict scrutiny, which is generally reserved for civil rights, to the, as you say, fundamental right to own a gun. Thank you. Thank you, Mr. Chair.
For further discussion,
Seeing no further discussion, the chair recognizes Representative Holt for closing comments on House Study Bill 9.
Representative Anderson, I apologize, I did have that information with me. It's Missouri, Louisiana, and Alabama have amended their constitutions to use strict scrutiny language. And they amended their constitutions after the landmark 2A decisions in 2008, 2010, because they believed it was the proper standard for protection of a fundamental right, and I would agree with them. Again, in the strict scrutiny language, the strict scrutiny language has been discussed a lot. This language is intended to prevent passage of future laws if they infringe on fundamental rights, such as the Second Amendment. It should not affect laws that do not prevent the exercise of core aspects of the right to keep and bear arms. Again, compelling government interest, narrowly tailored. That's the requirements for strict scrutiny. Why would anyone want a Second Amendment right? The Second Amendment is not a second-class right. To Representative Anderson's points about why would you have strict scrutiny on this? Because the Second Amendment is a fundamental right, just like the right of free speech, just like the right of freedom to assemble and freedom of religion. That's why it's the Second Amendment in our amendments, the second one. I think they thought it was pretty important. It is a fundamental right. We were reminded in McDonald versus Chicago that the Second Amendment is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. Fundamental rights deserve strict scrutiny. Why would anyone want one right less vigorously protected than, say, the right of freedom of speech or to peaceably assemble or freedom of religion? The Second Amendment is a fundamental right, just as is those other rights. Representative Russell Kershaw, I look forward to talking about truth over lies, because none of the things that you talked about that this bill would do, does it do. Again, if laws on the books are narrowly tailored to meet a compelling government interest, they'll be upheld under the strict scrutiny standard. And bazookas and tanks and all those sorts of things are covered under an entirely different part of federal code This has nothing to do with bazookas, tanks. We want to talk about fear mongering. This has nothing to do with bazookas and those type of weapons that are covered under a completely different section of code. And I look forward to talking about, Representative Anderson asked, why is this needed? What are we trying to do? I will cover that in my closing remarks. So, governments are instituted among men deriving their just powers from the consent of the governed. Those are profound words in our documents, founding documents. Government power comes from the consent of the governed. Our Constitution also sets out certain God-given natural rights: life, liberty, and the pursuit of happiness. These rights are called unalienable, not inalienable, because there is a profound difference in those two words. Unalienable is a right which cannot be sold, transferred, or in any way taken away. Life and liberty are unalienable rights for all American citizens. The right to someone's own life and the pursuit of their own happiness, their own destiny, cannot be separated from the right to defend that life. Hence, the fundamental right to keep and bear arms in our Second Amendment. This fundamental right to control our own lives and destiny, guaranteed in our U.S. Constitution, cannot exist without the right to defend our lives. The right of self-defense is as basic as it gets. It is a fundamental God-given right, recognized in the Fifth Amendment right against self-incrimination and in the Second Amendment of the United States Constitution. Numerous court decisions have shown that it is up to individual citizens to provide for their own immediate safety. Society as a whole, government has a responsibility to protect, but not each individual American citizen. And you can reference Warren versus the District of Columbia, the Appellate Court, 1981. How can one provide for their own safety and ensure their life, liberty, and pursuit of happiness without the fundamental right to keep and bear arms? So why do we need this amendment to Iowa's Constitution? Perhaps the better question is why we are only one of only 6 states that does not already have this fundamental right in our Constitution. We need it because it is profoundly apparent in 2021 that freedom and liberty are fragile and under greater assault than at any time in our history. We need it because the landmark Second Amendment case, Heller and McDonald, those cases were decided by only a 1-vote majority on the Supreme Court. Because 4 U.S. Supreme Court justices disagreed in those cases that the Second Amendment protects a fundamental individual right to keep and bear arms. And in their dissent, they created a roadmap for the future destruction of our Second Amendment. That is why it is critical to have this firewall in the state constitution, and why the strict scrutiny language is so important in preventing backdoor assaults and undue burdens on this fundamental right. Our language is written with the knowledge that 44 other states' constitutional provisions in many cases failed to protect against egregious gun control laws. Strict scrutiny language is of great importance in protecting this fundamental individual right. It is the highest level of review and requires the court to determine if the government's action is narrowly tailored, once again, to serve a compelling government interest. Current laws that take the least restrictive route to advancing a compelling government interest will be safe. The permit process, for example, has been upheld in other states. Let us remember reality as we discuss overreaching gun control laws that attempt to stop violence. These laws have shown themselves in many cases to be ineffective at mitigating violence, whereas armed, law-abiding citizens can be a great deterrent to crime. It is not about the gun. It is about the character of the person holding the gun. Self-defense is a natural, just, and legal reaction by law-abiding citizens to an illegal attempt by criminals to perpetrate violence or take their lives or the lives of those they love. Gun control laws are directed at law-abiding citizens. Think about this. But they are not the problem. It is the lawless of our society causing gun violence, and they are called lawless for a reason, because they don't obey the law. It is profoundly ridiculous to believe that putting up a sign for a gun-free zone will make citizens safer. On the contrary, that sign creates a potential shooting gallery, disarming law-abiding citizens while emboldening the lawless. By attempting through well-meaning laws to make it more difficult to obtain a firearm, let us remember that law-abiding citizens are at risk of losing their natural right of self-defense, even as the lawless are given the upper hand. And I suspect that most criminals do not obtain their firearms through legal means. So we need this amendment to have a firewall in our Constitution where the U.S. Supreme Court to overturn Heller and McDonald. And we need this amendment to stop backdoor attempts in Iowa to infringe on the fundamental right to keep and bear arms through taxation, attacks on gun manufacturers, or arbitrary laws that attempt to outlaw certain types of firearms. Representative Anderson, to answer your question, let's look at just a few cases right here in Iowa, in the Iowa House, to show why this amendment is so desperately needed. Numerous bills have been filed by Democrats to assault the Second Amendment rights of Iowans over the last few years. Confiscation. A bill was filed by Democrats to confiscate commonly used firearms such as shotguns, hunting rifles, and pistols used for self-defense. Seizure without due process. A bill filed by Democrats would take firearms from law-abiding citizens without due process. Denying permit to carry. A bill filed by Democrats would allow sheriffs to deny requests for a permit to carry without reason, walking back current law that mandates that sheriffs shall issue a permit to carry unless there is an established legal reason not to do so. Banning magazines lawfully used by Iowans. A bill filed by Democrats bans magazines that hold over 10 rounds and makes no exception for law enforcement, by the way. Banning what Democrats call semi-automatic assault weapons, and this is one of the ugliest. House File 125 that was filed defined certain firearms as semi-automatic assault weapons based on what the weapon looked like and would have prohibited their sale or transfer. Some things that might make your firearm a semi-automatic weapon, according to House Democrats in this bill, include pistol grips, threaded barrels for legal suppressors, folding telescoping or detachable stocks, etc. The bill goes on to list many cosmetic features of rifles, pistols, and shotguns that would qualify them as semi-automatic assault weapons. So these are real examples of legislation filed by Democrats in the Iowa House to assault the Second Amendment rights of Iowans. We need it. House Study Bill 9, a joint resolution proposing an amendment to the Iowa Constitution, reads as follows. The right of the people to keep and bear arms shall not be infringed. The sovereign state of Iowa affirms and recognizes this right to be a fundamental individual right. Any and all restrictions of this right shall be subject to strict scrutiny. Mr. Chair, for freedom, I advance House Study Bill 9.
Representative Polk moves to passage of House Study Bill 9. Clerk will call the roll.
Representative Klein.
Yes.
Representative Westridge.
Yes.
Representative Breckenridge.
No.
Representative Anderson.
No.
Representative Andrews.
Aye.
Representative Fisher.
Aye.
Representative Fry.
Aye.
Representative Gobble.
Yes.
Representative Holt.
Aye.
Representative Jenner.
Aye.
Representative Furr.
Aye.
Representative Pressing.
No.
Representative Poston.
Aye.
Representative Salmon.
Aye.
Representative Steckman.
No.
Representative Sunday.
No.
Representative Thorpe.
Aye.
Representative Wesson Rochelle.
No.
Representative Worthing.
Aye.
13 yeas, 6 nays.
Having received 13 ayes and 6 nays, House Study Bill 9 will move to the floor as a committee bill. At this time,